Hi, I'm Jim Covington on behalf of the Illinois State Bar Association for this week's issue of ISBA Statehouse Review. Today is January 26, 2012. The General Assembly will be meeting every week other than spring break starting next week, and they'll take a 2-week holiday break in the late March, early April, but will be in full swing until the end of May. 4 bills I'd like to briefly touch on that have been introduced recently. The first is House Bill 4077 by Representative Renee Kosel from Mokena, Illinois, and it creates a new crime of making a false statement to a peace officer or investigator. It has 2 elements to it: knowingly making such a false statement to a peace officer or investigator about a criminal matter, and 2, it requires that a prosecutor during the interview advise the person that it is a Class 4 felony to make such a false statement to a peace officer investigator. The second bill is House Bill 4129, filed by Representative Jerry Costello from Belleville, Illinois, and it sets forth the filing and notification requirements for judicially registering an administrative support order. And it provides that a non-registering party seeking to contest enforcement of a registered administrative support order must: 1, request a hearing within 30 days after the date of the service of notice of the registration, and 2, he or she seeking to do that or vacate the registration has the burden of proving that on several defenses. That's been filed and just introduced, and it's been sent to the House Rules Committee for a later referral to a substantive committee, and we will start those substantive committees next week. The third bill is House Bill 3943 by Representative Mike Zaliski from Chicago. It creates an exemption to the Eavesdropping Act to allow a peace officer or his or her designee, which would be an informant, to videotape, to record somebody, more accurately record somebody during what they consider to be a felony drug investigation without seeking or getting any prior court approval. And that has been sent to the House Rules Committee for later referral to a substantive committee. The fourth and final bill is House Bill 4098 by Representative Dwight Kay from Glen Carbon. It requires the Supreme Court, and I'm not sure how the General Assembly can do that, but it requires the Supreme Court to adopt rules to require that any attorney that appears in front of a judge that has given the judge or his or her law firm more than $500 in the previous 5 years to disclose that and give the other party a reason to disqualify that judge from hearing that particular case. That has been filed and introduced and will be sent to House Rules for later referral to a substantive committee, and we will see you next week. Thank you.